Hello and welcome to this episode of Law for Lawmakers. I'm Fiona Rutherford, Chief Executive of Justice, the law reform and human rights charity, working to create a fair, effective justice system within everyone's reach. This podcast is based on our Law for Lawmakers guide. The guide is designed to help repair the cracks in the UK's political foundations by giving every MP the tools they need to act as custodians of our democracy. It explains the key legal and constitutional principles that underpin good lawmaking, helping parliamentarians and their staff review new laws, table and write amendments to bills, support their constituents and hold power to account. But this podcast isn't just for parliamentarians. It's for anyone who cares about how laws are made, how rights are protected, and how our democratic institutions function. Each episode brings together leading voices from law, politics, and public life to explore the legal principles that shape our society and to demystify the role Parliament plays in upholding them. In this episode, we're discussing artificial intelligence and the rule of law, and what that means for parliamentarians when debating and scrutinising emerging technologies. I'm joined today by Justice's AI expert and Senior Lawyer Ellen Lefley. Ellen oversees our programme of work on artificial intelligence, including our landmark report on AI in our justice system, as well as our most recent report entitled AI in Policing, International Lessons and Domestic Solutions. She regularly briefs parliamentarians on a range of AI issues as they arise in various bills, and in fact gave evidence to the Joint Committee on Human Rights just last month. Ellen, welcome. Thank you for joining the podcast today. So I'm going to get right into it. What are some of the rule of law challenges in the context of the increasing use of artificial intelligence in our justice system?
Yeah, thanks for having me, Fiona. So with respect to artificial intelligence, obviously this is such an exciting area because these are new capabilities. This is technology which at its core is doing things that for all of history up until now we thought that only humans were intelligent enough to do. And it's now being done artificially by computers. So there's a level of adaptivity and autonomy to machines which we, as humans in society, are figuring out how to place rules around. And that's where the intersection with the rule of law comes into play, of course, because the rule of law, at its heart, at its core, is about what it isn't. It's about saying, no, we don't want rule of power. We don't want rule of bullies. We want rules to constrain power, and we want those rules to be decided not by the most powerful, but here we say democratically. And we, as a society, are on that journey now to figuring out what rules we want to constrain this emerging technological capability. And so far, there's been a lot of work around what ethics we need that will give us some core principles to apply. But also, it's becoming really clear that it really depends whose hands this technology's in terms of what rules we want to apply, what they're going to do with it. And those two factors really determine how strict we want the rules to be. But in terms of who decides, key tenet of the rule of law and how it works with the democracy, that question is for all of us. And that's why the interaction between AI and the rule of law and finding those rules that work for us as a society is such an important and ongoing policy area.
So you've mentioned principles, and you led, as I've just said, on the landmark report that Justice published in relation to AI and our justice system. And in that, you've set out some of the principles that should govern its use in the system itself. Can you tell us a bit more about this work and why a principles or a goals-led approach is so important?
Yeah, absolutely. So this was us looking at, as Justice does, really honing in on when this technology is used in our justice system. Because you can ask ChatGPT to write you a story and it might be a bit rubbish, but it doesn't really matter. There are loads of uses of artificial intelligence that can be fun and can be low risk. But what we analysed is that our justice system, which determines people's civil obligations and rights, decides whether they're going to be imprisoned or not, or whether they're going to care for their children, that is not one of those low risk domains. This is a high risk domain where it really matters where if mistakes are made and harm is done, and where we shouldn't really be just moving fast and breaking things, because when we break things in the justice system, people's lives are ruined. So when it comes to those high-risk domains, our report sought to really reiterate the importance of innovating with purpose, and that's the goals-led piece. What are you trying to do here? Is the art of the possible actually needed here? Is there potential for unintended consequences that could really harm people? So taking that goals-based approach, what are you trying to do, and is it going to improve the justice system? And then being vigilant as to the risks that may be implicit or explicit from the use of artificial intelligence within that domain, within the justice system, along established principled lines of what human rights and rule of law principles our justice system protects. So we all know that there are quite simple ones, that you can't imprison someone without there being lawful evidence that would necessitate it under law. You can't infringe someone's privacy unless there is a necessity and a legitimate aim, and that infringement is proportionate. So we're not saying that we need to start from scratch here just because artificial intelligence is being used. We need to have recourse to our established human rights and rule of law principles, and we need to make sure that we're not ignoring those just because it's a new shiny technology, and remembering that at the end of the day we need to be goal-led and really quite tight to that goal and vigilant to the risks when we're operating in a high-risk domain like our justice system.
Well, since doing that first report, you've been focusing turning your attention, I suppose, to particular areas or types of use of AI. Most recently, with respect to policing, what did you find most surprising when researching this area?
We research internationally as well as in the UK, and one of our key findings was that in England and Wales, sorry, I said the UK, but we focused on England and Wales, and Police Scotland is obviously its own thing, which wasn't part of our remit. We looked at England and Wales, and it was really surprising to see that currently artificial intelligence adoption by police is, well, I would use the term Wild West, and I don't use that term lightly. There is a lack of centralised standards in terms of the quality of the models that are being used. There are no clear rules about, or certification or authorization process in terms of what models are good enough for what type of purpose. And also there's a real lack of legal clarity. We don't have a single bill or act on the books that uses the words artificial intelligence, nor do we have one that uses the words facial recognition technology, which is probably the most famous and most broadly used piece of artificial intelligence in policing. What we have is a patchwork of existing laws, human rights, equality, data protection. Now, that is a valid approach, but the problem is that when you're operating on a patchwork of laws, it lacks real clarity for the police officers who are deploying it, as well as the public. And so we really found that there's a lack of understanding as to, I mentioned at the start of our conversation, we really need to be setting rules about who can use what and when, what's compliant with human rights law. And at the moment, we actually don't have a clear set of rules for police to abide by, for example, with facial recognition, which means that we have 43 different territorial police forces, each writing their own rules as to how they're using facial recognition technology. Now, that doesn't sound to me like good equality before the law in terms of the extent to which you're overseen by this powerful technology in one constabulary area versus another. And it just lacks that basic tenet of foreseeability and accessibility of the law. So one of the things that we really learnt from our review is that we need professional standards, we need good oversight, but we really need some more legal clarity. And that's why we're supporting a new legislative framework, particularly for biometric technologies like facial recognition in policing.
Both those reports are available on our website and has a huge amount more information and detail in them. But I'm going to move us on now and talk about something that we frequently hear about AI, and that it will solve the problems, the many existing problems with regards to access to justice, which is, of course, another key tenet of the rule of law. What's your take on this? What does the evidence actually say at the moment?
We actually don't have much evidence at all as to how people are using this technology. It's because there are loads of really interesting consumer, we're talking mostly AI chatbots here, like your ChatGPT like Google's Gemini or like Claude from Anthropic, publicly accessible chatbots where people can ask questions and get tailored information. And that is access to reliable, tailored advice and information for legal problems is the holy grail of the access to justice crisis that we've had in this country. The problem there is the word reliable. The problem there is the word trustworthy, because we shouldn't accept that just any information or any advice is good enough. We need it to be reliable and trustworthy. I have no problem with tech optimism. Tech optimism is about embracing innovation, looking to new solutions to tackle old problems. That's an important perspective. And I think there's lots that responsible innovation for access to justice can do. But I think we mustn't look at this with tech solutionism, that AI is going to solve the access to justice problem, that we just need to have more people asking ChatGPT whether they can, withhold their rent from their landlord rather than just, blindly walking into proceedings without any, guaranteed reliability of what's coming out of these chatbots. We really can't look at it as the panacea. The key problem there that I suppose I'm hinting towards is the lack of regulation, but that's not an easy thing to solve at all unless you're conducting litigation or another reserved activity in this country. Giving someone just a bit of legal advice, that's completely unregulated. If we wanted to start regulating that, there would be consequences in terms of people's ability to just get some advice from law centres, from family, from friends about legal problems. And then there's feasibility issues as well in terms of regulating big tech, especially when it's not operated from within the UK. We're not talking about just sovereign regulation, we're talking about international regulation. So there are big problems, both in terms of what the risks look like and in terms of the feasibility and our operational capacity to actually make any solutions work, especially if we're looking towards regulation. And finally, on that point, can I also just add, more access to justice is a very good thing, but we also need to be very mindful that we are working at around, I think the last survey of legal need in this country showed that about 2/3 of us will have a legal problem within 4 years, but only half of us will get legal help. So if we're talking about that number of extra people who currently have unmet legal need, having met legal need, even if some of it's unreliable, we're talking about a lot of, because I'm not talking about vexatious claims here, I'm talking about a lot of additional legal empowerment in this country. And so we can't think about AI advising people and helping them with access to justice as a discrete good problem that won't affect the justice system. It is going to affect the justice system massively. And so we need to be thinking about how we ready our courts, tribunals, and dispute resolution services properly in terms of funding and in terms of their capacity, including technology, but not exclusively technology, their capacity to deal with that potential influx of work. What I'm saying here is that the impact of AI on access to justice isn't just in the advice and information realm. It's throughout our justice system, and we need to be thinking systemically about it.
And we know, you've mentioned the capacity word. We know that capacity in the criminal courts, it's a familiar headline now, is in a fairly dire situation. And that's true for those people who don't go beyond the criminal court headlines. It's true across many of the jurisdictions in our tribunals and courts across this country too, and that there is this capacity issue. But I want to go back. You mentioned something earlier about legislation and how there is no mention of artificial intelligence specifically articulating legislation. Legislation is, of course, generally led and put forward by central government departments, and different government departments can often have different approaches to the way in which what they want to legislate on for obvious reasons. You have been doing work, I know, with regards to legislation coming from the Department for Work and Pensions, as well as the Ministry of Justice. How do these different departments, or is there a difference in the way in which these departments are treating AI and how they're approaching it?
Yeah, absolutely. I mean, as I said earlier, and you've just picked up on then, we don't tend to get explicit reference to the tool, to the artificial intelligence. That can make its way into the policy, or sometimes it doesn't even there. It's being treated currently as a tool, a mechanism through which certain powers, existing powers or new powers, are being exercised. And again, we come back to the rule of law, because the rule of law is all about preventing the arbitrary exercise of power, needing to make sure that that relationship between the citizen and the state is not one of subjection to power, but is power constrained by rules. And some of the concerns that we've had with the legislation coming out about DWP's access to information about benefits recipients is that there are new powers which are being legislated for to access the bank accounts of benefits recipients, to check whether they are defrauding the public purse. Defrauding the public purse, obviously a legitimate aim, but our real concern around necessity and proportionality of this measure is that there's no requirement for there to be any reasonable suspicion that there's any fraud in the first place. So we're talking about mass surveillance of people's bank accounts, which of course would be completely outwith the capacity of a government department being able to check up, putting to one side the human rights proportionality argument, that just simply could not be done previously. So what we have is new powers that previously were not even within anyone's mind's eye, because it was just, it would be an impossibility. There's not the manpower, there's not the hours to trawl. But now that can be automated, suddenly that's possible. But of course, the method of automation isn't making its way into the statute books. The simple power is. Now, actually, this one is going to be outsourced to the banks. And so we also have there an outsourcing relationship of it's the DWP being able to order that banks conduct this surveillance. And so we also there have a really interesting and important further factor to all of this, which is the shared intrusion into privacy and the shared empowerment of, hitherto unknown levels of mass surveillance and intrusion shared between public and private actors. And that's something, when we're talking about protecting human rights, we're always trying to actually think about the human at the end of it, the individual at the end of it, and protecting their human rights, but thinking about how we actually make that enforceable and reliable when it's bridging between those private and public gaps is something that it requires a lot more thought. I don't know if I've answered your question there about the difference of departmental approaches. I think it's more about my message to lawmakers would be a simple Control F search of the bills that are coming through Hansard to see if they're mentioning this technology. That's not the approach that I've found to be valuable or impactful. It's far more under the surface level than that. It's trying to it's a question of trying to identify where new technological capabilities are empowering the state to take new powers, new capabilities, and where that might be changing the relationship between the citizen and state, particularly with regards to surveillance and what we want the rules to be for that.
Well, that's a really nice segue into the question I was going to ask next, which is around how should parliamentarians approach the use of AI in the justice system per se? Like, what advice would you give them?
I would
not Control F. Flag that.
Yeah. I mean, it's an unenviable task, but it's such an important one, because really those in Parliament are the ones who are going to conduct this within our representative democracy. They are the ones who are conducting the engagement with communities and representing their interests in that lawmaking place in which we actually decide what role these technologies are going to play. My advice would be, as I said, not to simply look for the mention of these technologies, because they're finding their way into how people are operationalizing their powers and capabilities, rather than there being necessarily new rules coming forward. So I would advise vigilance with that, and also a strong focus on rules being restrictive rather than permissive when it comes to the use of technologies in new areas of power, which are going to significantly change, as I said, that relationship between the state and the individual. There will be an ongoing creative approach to using these technologies to do what we've never been able to do before, and that in some areas is going to reap real benefits for people. There are possibilities of it making people safer. There are also possibilities of it being able to undermine our human rights like we've never seen before. So being able to really scrutinise within Parliament what the rules are that are going to constrain use, what, who's going to be checking, and what independent oversight there is over use are some of the key questions that I would be asking when any of these policies are being debated in Parliament, and of course, when legislation is coming through.
There's a lot in there, a lot for parliamentarians to think about. And of course, Justice, I'm sure, via you, Ellen, and others, stand ready to support in any way we can. We've had on a previous episode the legal director and the director of strategy for Justice, and I've asked them this question. I hope you don't mind in wrapping up if I might ask you the same question, which is around what motivated you to join an organisation such as Justice that is seeking to protect and promote the rule of law as a sort of key facet of our work.
Yeah, I mean, I think my answer is quite personal, actually, which is, I think one of my values is I want my work, how I earn money in this world, to be something that I feel proud of and be contributing towards public good and social good. And I practiced as a lawyer before Justice, and I felt that the legal profession is so important, but you also, if you're interested in policy, you can't help but notice when you're a lawyer doing cases, just how much you're seeing some of the same problems, repeated issues. And I think when I was practicing, I felt like sometimes I felt a bit of a cog in a broken machine. And I started to think about, well, what's going to change this machine, how it operates, and how it can be improved. And that was really the motivation that led me towards applying for Justice and working here for 6 years now. And I'm very proud to do so.
Well, thank you so much, Ellen. We will draw it to a close now. It's been great speaking to you. Thank you, Ellen, for joining me today to discuss this fascinating issue. And thank you to all of you who tuned in to listen to Law for Lawmakers. We designed this guide not just for parliamentarians, but for anyone who cares about the rule of law, whatever your background. To learn more about our work and to access the guide, visit www.justice.org.uk. And if you found this episode insightful, do like, subscribe, and share it with your colleagues, friends, families, people you work with, anybody, in fact, who cares about the future of our justice system. I look forward to speaking to you on the next episode.